Hello, welcome to this season's sixth episode of Schwegman, Lundberg, and Woosner's Chemistry and Biology Seminar Series. I am Nicholas Lanzatella, your moderator for the series. During this series, attorneys from the SLW law firm having a background in chemistry or biology will present on various topics at the intersection of the chemical or biological sciences and patent law. We will aim to give these presentations on the second Tuesday of each month. If you attend 3 or more of these presentations live and you live in the US or have a mailing address in the US, we will send you a free gift. Slides for today's presentation will be available in the chat and a link will also be emailed to you. As a reminder, nothing in today's presentation should be regarded as legal advice. If you are seeking legal advice, please consult your counsel. I'm pleased to introduce our speaker for today, Alexandra Cavazos. Alex is a senior attorney at the firm and is a registered patent attorney who is an expert in the biological sciences. Alex has extensive experience with next-generation cell therapies, including CAR-T and CAR-B cell technologies, as well as RNA-based therapeutics, such as mRNA vaccines and lipid nanoparticle delivery systems. Alex is well-versed in CRISPR-Cas genome editing, biospecific and anti-CD20 antibodies, gene therapy vectors, and large molecule biologics. Alex also has significant background in patent litigation, including Hatch-Waxman, PTAB, and IPR proceedings. Alex's litigation experience informs her patent prosecution strategies, making her a strong client advocate. Alex has a bachelor's in fine arts from Harvard University, a law degree from UCLA School of Law, a bachelor's in cell and molecular biology from San Francisco State University, and a PhD in molecular and cell biology from University of California, Berkeley. Alex's presentation is titled Precision Functional Claiming, Strategic Use of Section 35112F to Protect Biological and Chemical Inventions. If you do have questions, please put these in the Q&A. There's a Q&A box at the bottom of your Zoom window. Please click that and enter your questions there instead of the chat. If you do that, Alex will answer your questions during or after the presentation. Go ahead and take it away, Alex.
Thank you, Nicholas. So here I'll be talking to you today about a claiming tool that many patent prosecutors and the life sciences have dismissed as belonging solely in the predictable fields like mechanical engineering or electrical engineering. And that tool is means plus function claiming under Section 112F. What I hope that our listeners take away from today's talk is that MPF claiming, when it's done strategically and carefully, can be a useful tool for obtaining intermediate claim scope. I will, before I begin, I just want to note that any statements or opinions that I express today are my own personal opinions and not those of SLW or any of its clients. And any advice and recommendations that I give you today are not intended as specific legal advice. Okay, well, with all that done, let's dig in. We've got some really fun stuff to talk about today. I'm going to start with a brief overview of Amgen versus Sanofi and Juno v. Kite, two cases that many practitioners believe have sort of made broad genus claims more difficult to get. Then we'll cover the statutory sort of framework for MPF claiming. And the heart of the presentation today is going to be a close look at two cases, Ex parte Chamberlain, which applied MPF claiming strategies in the antibody context, and ex parte Gleave, which applied it to antisense oligonucleotides. Then we'll look at whether this framework extends to small molecules and chemical sciences more broadly. And we'll close with some recommendations and key takeaways. And I do aim to leave a few minutes at the end for questions. And please, I encourage everyone who has experience with these, or if you don't have experience with MPF claims and you've got questions, please feel free to share them in the chat. Okay, So let's talk a little bit about the post-Amgen landscape that we're in. That's what's making this conversation necessary. Now, why are we talking about means plus function claiming in 2026? And that's really, for me, that starts with two decisions that reshape the boundaries of functional claiming in the life sciences. And the first of those was Amgen Inc. versus Sanofi, a 2023 decision from the US Supreme Court. I put up sort of the main representative claim here, claim one, and I'll give everyone a few seconds to read it. Okay, so Amgen had claimed an isolated monoclonal antibody that when it bound to the protein PCSK9, that it would also bind to it at one of these specific residues listed in the claim. I think there's 15 or something in there. And these, when it would bind to these specific residues, it had to block binding of PCSK9 to the low density lipoprotein receptor. So this whole case, just as a refresher for people, I'm sure everybody's probably already heard of it, but it involved antibodies that lower cholesterol and lower people's risk of cardiovascular disease. So Amgen's patent disclosed 26 specific antibodies that met the claim limitations. But as you can see, the claim as written, potentially covers millions of antibodies that had not been made or tested. So when Amgen asserted, these and other claims against Sanofi, Sanofi responded and argued that Amgen's claims were not enabled. And the Supreme Court agreed with Sanofi, and they agreed with them unanimously. So the opinion emphasized that Amgen had not identified a quality common to every functional embodiment. Instead, the court focused on the fact that scientists would need to rely on what the court called random trial and error strategies to figure out which antibodies in that vast space would actually work. So this decision sent a clear message to practitioners, to the USPTO, and to the courts. If you were claiming a broad functional genus supported by the disclosure of only a small number of species, your claims are going to face serious enablement scrutiny. So if Amgen tightened the enablement requirement, Juno v. Kite, a Federal Circuit decision from 2021, did the same for written description. Now, this case involved a chimeric antigen receptor technology, so CARs, targeting CAR T cells, targeting CD19 on the surface of B-cell lymphomas. And Juno's patent claimed nucleotide sequences encoding CARs that included a single chain variable fragment, or an scFv, that binds to CD19. And so when this case went to trial, so Juno asserted these claims and others against Kite Pharma, saying their CD19 scFv infringed these claims. There was a 2-week trial, and at the end of the trial, the jury awarded Juno over $750 million in damages, which by the time this case got to appeal before the Federal Circuit, that number had grown to $1.2 billion. So at the Federal Circuit, the court found that the written description requirement was not satisfied. And I'll show you here, they're sort of the key phrase from the decision. The court said, while it's true that scFvs in general were known and even known to bind, the record demonstrates that for even the narrowest claims at issue, the realm of possible CD19 specific scFvs was vast, and the number of known CD19 specific scFvs was small, 5 at the most. And the court focuses on the fact that the 190 patent provided no details about which scFvs bind to CD19 in a way that distinguishes them from those that don't. And so without that guidance, under the controlling area decision, the court held that no reasonable jury could have found that the 190 patent satisfied the written description requirement. So between Amgen on enablement on one hand and Juno on written description on the other, by 2023, we've got this landscape where, broad functional genus claims are facing a very narrow path to allowance. And, the more you claim by function, the more you're going to have to disclose to support that functional breadth. Okay, so that brings us to what we can do if these broad genus claims are harder to get. This really is a tool that's been underutilized. And what's good about this for us is that, now we get to talk about a statutory framework, an alternative claiming framework that actually lets you claim by function, and where a single disclosed structure in your specification can allow you to support your functionally defined limitations. So it's a very unique tool. And you don't need to describe the entire genus, as I'll explain in more detail, because the statute that sets up means plus function claiming extends your protection to include equivalence. So this has been in the Patent Act since 1952, and it's section 112F. Right? Let's talk about how we might be able to use some of this to our benefit. Okay, so we'll begin with the statutory text, right? I want to make sure everybody's got a solid grounding in how the statute sort of works, because the details do matter. Okay, so I'll give everyone a minute to read the statutory text. Okay. So section 112F basically says that, I'll paraphrase a little bit, but that an element in a claim for a combination can be expressed, right, as a means or a step for performing a specified function without the recital of structure, and such claim shall be construed to cover the corresponding structure described in the spec and equivalents thereof. And just to keep it, easier for us, when I refer to, you have to recite structure in your specification, I do want people to remember that the statute is structure, material, or acts, right? So there are different ways that you can support the specified function in your claim. But just for brevity's and simplicity's sake, I'll just say structure, but just know the statute does have those other two in there. Okay, and so how do you invoke it? You put a claim that recites a specified function, but you don't say what that function is, right? You don't say the structure that performs that function. Okay, so your claim just recites a function, but doesn't tell you what performs that function. What tells you what performs that function is your specification. So if you want to satisfy 112F, you've got to make sure that your spec tells you at least one corresponding structure, material, or act that performs the specified function. And what equivalents are covered? And that's an interesting and pretty deep question, but we'll just have time to barely touch on it today. But basically, your claim is extended to the equivalents that were known before your patent issued, right? So there's a temporal limitation here. It cuts off at patent issuance. And I've put here that those equivalents are assessed via the function way result test, but I've got a little asterisk because this is still kind of an open issue. And I think there's some uncertainty as to whether it's going to be the function way result test or the insubstantial differences test. That sort of remains to be seen. Okay, but notice what the statute doesn't say. It does not say that you have to describe all your equivalents. It doesn't say that you have to enable all those equivalents. The equivalents follow by the operation of the statute. So that's a fundamentally different framework from genus claiming, right? Where pretty much every member of the genus has to be enabled and described. And maybe it's not every member, right? I think there's some disagreement among us over how tough the enablement description standards are. But what I can tell you is that they're definitely tougher than they used to be. And so this difference between means plus function claiming, right, and sort of claiming through these functional genus claims is really what can make MPF claims useful in our post-Amgen landscape.
Okay, so Alex, a quick question for you on your last slide. So are 112F equivalents the same as equivalents under the doctrine of equivalence?
No, they're not the same, and this is a pretty important distinction, right? So Section 112F equivalents are sort of baked into the literal scope of the claim. They're part of claim construction. And when a court construes a means plus function limitation, it identifies the corresponding structure in the spec, and then it asks what structures are equivalent using, right, the function weight results test. At least that's what's been used in other scientific areas, right, outside of biology. And that's assessed as of the date the patent issuance. So anything that falls within that equivalence analysis is within the literal scope of the claim. Now, the doctrine of equivalence, in contrast, that's an equitable doctrine. It extends infringement beyond literal claim scope, and it's assessed at the time of infringement. Okay. So you can, I think, in theory, get both, but that's sort of I think that's a deeper question. We don't have time to get into all that, but as a practical matter, I think the 112F equivalents are your sort of primary tool, right? And you should draft your spec sort of with the goal of making those statutory equivalents as robust as possible. Don't count on the doctrine of equivalence as opposed from your 112F equivalents to sort of save you, because that doctrine, I think, has a lot of limitations, including things like prosecution history, estoppel, and I have a feeling that we really don't know, really, is right, because there's not a lot of case law on this issue in our areas. But in my view, I think there's a chance that 112F equivalents are going to be broader. I hope.
Interesting. Okay. I have another question for you from the audience. In your opinion, does sort of your thesis about means plus function claims in this presentation, does that apply also to software and AI inventions and their claims? Can you please comment on that?
Well, I certainly don't see anything in the statute that says they don't, and I know that they do, and they have been applied, although I will tell you now, you're a little bit outside of my wheelhouse of experience. But yes, I definitely know for a fact I've seen cases that involve MPF claims in those disciplines. Okay. All right, so I'll get back to it then, Nick.
Yes, please go on.
Okay, so okay, so 2181 and 2187 of the MPEP is where sort of the instructions to the examiners for how you identify an MPF claim limitation under 112F. And I'll just briefly run through that. But, first they check and see whether your claim limitation uses the word means or the word step or some substitute that's considered a generic placeholder term for performing the claimed function. Then they see if that placeholder, is modified by functional language and linked by a transition word like for or configured to, right? And then third, they check that the means or step or your generic placeholder term is not modified by sufficient structure, material, or acts for performing the claimed function, right? So that there has to be a division between, saying the function in the claim and then telling them in the specification what the structures are that perform those functions. But if you try to do a little bit of telling them what performs that function in the claim itself, right, then it's not going to fall under, or you'll throw it into question whether you're under the 112F rubric. Okay, so let's assume all three prongs are met. Then 112F is invoked, and the examiner has to construe this limitation by turning around and identifying the corresponding structure in the spec. And I'd really flag the USPTO put out a memo in March 18th, 2024, on evaluating MPF claim limitations. And it reminds examiners to make their Section 112F analysis explicit in the record. And it says that in the memo. So that can be very useful if you've got an examiner who doesn't want to treat your claim under this proper framework. Okay. So now we get to sort of the heart of today's talk, and I'm excited to talk about it because it's a pretty interesting story. Now it's pretty convoluted. It's got a lot of back and forth. So I'm going to have to sort of simplify and gloss over some nuances because we don't have all that time. But I still think it's really worth it to dig in as much as we can because this is a pretty critical case for those of us in the life sciences who are interested in using MPF claiming strategies. Okay. So the Chamberlain case is really a tale of two antibodies, eculizumab and ravulizumab. And these are antibodies, monoclonal antibodies, both of which bind to a human protein called C5. And both of them are used to treat a rare disease called PNH. And PNH is a disease in which the red blood cells of your body lack a protective lipid on their surface. And so the red blood cells that don't have that protective lipid get attacked by a complex of proteins that include portions of that human C5 protein. Right? And the full name for PNH is paroxysmal, forgive me if I massacre this, but it's paroxysmal nocturnal hemoglobinuria. And the attacked red blood cells are destroyed, and then their fragments form blood clots in the person's body, in the blood vessels. And it's a terrible disease. And so when eculizumab, who was the first antibody to come out to really target this C5 protein, it was a big deal, and it really sort of started a whole field of people being interested in targeting human C5 and the human complement system, right, to fight this condition and various other conditions. So, pardon me one second. Okay. So eculizumab was approved by the FDA to treat PNH back in 2007, and eculizumab is also known by its sort of original designation when it was a mouse monoclonal antibody directed against the mouse C5 protein. That it was called 5G 1.1. So that becomes important for us later on. So know that eculizumab's in its early stages was known as 5G 1.1. Okay, now I've got the structure up on the slide because it's helpful for us to know, okay, well, these two antibodies I'm going to tell you about are related, and they're related in the sense that their amino acid structure is identical except for 4 differences. And ravulizumab is, sort of the next gen version of eculizumab, and it has 2 mutations in its FCC region here, this CH3 box that you're seeing. That's in the FC region. So M428L, N434S, those are 2 amino acid substitutions in this Fc binding domain. And the other two are tyrosine to histidine in the CDR1 and serine to histidine in the CDR2. Okay, so there's 4 differences between these 2 antibodies. And the histidine substitutions in the CDRs, those enable pH-dependent release of the complement C5 protein in the acidic endosome, right? And that allows ravulizumab to be recycled rather than degraded. And then these other 2 substitutions these are known in the field sort of as the LS substitutions. They're very well known in the field of therapeutic antibodies, right? Because they extend the antibody's half-life by altering its binding to the human neonatal receptor. So by having these mutations, particularly here, ravulizumab has a half-life that is, I think, close to 50 days. And eculizumab has a half-life that's about 11 days, right? So that's a huge difference. That means that eculizumab is, administered every 2 weeks, and ravulizumab can be administered every 8 weeks. So for people with this disease and other diseases that these antibodies can treat, that's huge, right? If you can imagine the time, the cost savings, and just so many benefits to having an extended half-life. So Xencor is the company that developed this LS mutation in the Fc domain, and they call this innovation their Extend platform. And so it was kind of a plug and play, right, type of discovery. So they were able to, get significant licensing revenue, right, by patenting this and getting companies to pay them in order to be able to put this substitution into their therapeutic antibodies. One of the companies that Xencor was getting royalties from is a company called Alexion, and that's the company that makes and sells ravulizumab. So the context for all this, right, for the whole Inree Chamberlain litigation is really, Xencor knew that their early patents on this, Extend platform, right, where they use these LS mutations to get longer half-lives, it was going to expire. Most of their patents were going to expire in 2025. So Xencor needed to get claims that covered ravulizumab, and they needed to get those claims allowed, right, and issued in order for them to be able to continue sort of demanding royalty payments from Alexion on the sales of ravulizumab. So the application that we're sort of be looking at in detail in Chamberlain is, from a family that if this claim was allowed, it would have resulted in a patent that would have expired in 2028. So it was still a pretty old family, right? But it had the latest expiration date, right, that I think Xencor could get. So we're really trying to get additional time to get these licensing revenues. All right. So I'll give everyone a second. These Xencor basically, when they filed these application to try to cover ravulizumab, before prosecution even really got underway, they had canceled the original claims, right, and put in these 2 claims 8 and claim 9. So I'll give everyone a couple of seconds to read the claims and really focus on claim 9, because that's the one we're going to be talking about in detail. Okay. So claim 9 is going to be the means plus function claim that we're going to focus on for the whole Chamberlain case. And as you can see, it's a method of treating a patient by administering an anti-C5 antibody. And our big means plus function limitation here is in part A. It's comprising means for binding human C5 protein. And and then reciting an FC domain that has the two, the LS substitutions, right? And that antibody with these amino acid substitutions has increased in vivo half-life compared to an antibody without those substitutions. Okay, so then we'll look at, just for everyone to know, okay, this is how we know for sure that they were targeting ravulizumab with this. They said so in their, when they made their claim amendments. This is February 27th, when they canceled the first 7 claims and added the claim 8. And they're telling us, okay, well, they want to draw the examiner's attention to several references, and they're directed to the use of their LS amino acid substitutions in the FC domain of eculizumab, an anti-C5 antibody marketed under the name Soliris. And this is how you get a new antibody, ravulizumab, now marketed under the name Ultomiris. Okay, so they're, if this is ravulizumab focused, this is why they're doing it. Okay, then we look at the support in the specification. And this is pretty much it. I'll give everyone a second to read the part of the paragraph where they mention the 5G 1.1 antibody. Okay, so this is pretty much it as far as the support goes for the structure that performs the function of binding human C5, right? So if I go back to our claim, okay, it's a means for binding human C5 protein. So the structure has to be here, an anti-complement C5 antibody such as 5G 1.1. So it's basically a laundry list of other types of antibodies that may be able to use this extend technology, these LS substitutions. And you can see that it jumps from anti-B2 integrin antibodies to anti-C5 antibodies to anti-CD2. Right? It's an alphabetical laundry list of different antibodies. There's no sequence disclosed, no CDR definitions, no binding affinity data, right? No epitope mapping, no humanization details. And as a matter of fact, the word eculizumab doesn't even appear in Xencor's specification. Okay, so I really want people to sort of appreciate this is pretty thin as far as description, right, of the structure goes. And what's fascinating about this case is you've got a 5-year battle, right? 2 final rejections, 2 Federal Circuit appeals, an appeals review panel decision, which was like a first ever occurrence. And all of it turned on whether naming this one antibody, 5G 1.1, could serve as an adequate corresponding structure to support a means plus function limitation. Okay, so let's take a look at how all of that played out. Okay, round 1. I put claim 9 up there just to remind people, just the first part of the claim. But basically, the examiner says, okay, means for binding in your means plus function limitation is vague, and the spec doesn't set forth specific structures. You're just basically telling me 5G 1.1. That's your structure. That's your description of the structure that performs this binding C5 protein. The examiner also rejects it, so it looks at it as a 112F, means plus function limitation, acknowledges this is a possible corresponding structure, but then concludes that's not enough. You don't have enough in there. And sort of critically, the examiner also rejects it under 112A, saying that invoking this 112F, statutory provision for analyzing means plus function claims does not exempt you from compliance with the rest with 112A, right? You still have to fully enable, you still have to fully meet your written description. Okay. So this goes up to the PTAB, and 1 second. All right. So the result that the PTAB, and I won't, here's where I know we're halfway through here, so I'm not going to get into too much of the gory details, but just know that there was a lot of back and forth here. The PTAB issued one decision, then the director stepped in and they vacated that decision. They had a rehearing. And so here we are at the PTAB's decision on the rehearing in 2023, and the PTAB affirms both of the examiner's rejections. And they say, with respect to written description, means for binding is construed as a chemical genus covering the disclosed structure and equivalence thereof. So the UC versus Eli Lilly antibody standard, right, of written description applies. And then also they affirmed the rejection for indefiniteness, saying that the failure to disclose adequate structure results in the claim being of indefinite scope. Okay, so the core thing here to take away is that their thinking was 112F compliance doesn't obviate an independent Section 112A analysis. Naming 5G 1.1 is not the same as describing 5G 1.1. Okay. So if the story had ended here, well, we probably wouldn't be having this talk. But luckily for us, it didn't. So at round 3, Xencor appeals to the Federal Circuit, but before the briefing started, the PTO director moved to remand the case because of the quote unquote novelty and complexity of the analysis of means plus function claims in biotech. So the Federal Circuit, even though Xencor had already filed its opening briefs, granted this motion that the PTO director had made and sent it back. And this triggered something that had never happened before, right? The office had its first ever appeals review panel decision. And that decision with Judge Lurie and I think some of the other, big hitters, issued on May 17th, 2024. And with respect to the MPF limitation, the appeals review panel sided with Xencor, right? They held that 5G 1.1, which they construed to include both the original mouse antibody and eculizumab, which is the humanized version of that mouse antibody, was adequate corresponding structure because both of them were well known in the prior art with publicly available sequences. So, and then the appeals review panel said the specification does not need to describe equivalence of the corresponding structure. The equivalents follow by operation of statute. Okay? And that was really critical for us, right? So that was a pretty direct, clear statement that MPF claims are different from genus claims, and you only need one corresponding structure. You describe that structure, and the equivalents are going to flow through because of the statute, right? Not from your specification. So the ARP reverses the indefiniteness rejection of the MPF claim limitation. Okay, the bad news is that the ARP then finds a new ground for rejecting the claim, and they focus on the treating a patient in the preamble. So that was held to be limiting because the claim, the rest of the claim outside of the preamble referenced increased in vivo half-life, which put the claim in a therapeutic context, and therefore the preamble sort of breathed life into the claim. And so then the specification provided no working examples of treating any patient for any disease with the antibody 5G 1.1 or with any C5 antibody. So that 112 rejection was maintained, but for a fundamentally different reason, right? And so it was sort of a half win, but really the preamble, as far as the ARP was concerned, was what brought Claim 9 down. Okay, round 4, we get to the Federal Circuit. And at the Federal Circuit, the case was styled in re Xencor. This came out in March of 2025. So critically for our purposes, the Federal Circuit actually, in its decision, didn't reach the 112F issue directly, right? It didn't need to, because basically it affirmed that treating a patient preamble was limiting, and that there was no written description for treating any patients with these anti-C5 antibodies described in Xencor's specification. And I should say anti-C5 antibody, right? 5G 1.1, there was no support for 5G 1.1 being used to treat anyone. Okay, so they affirm the rejection, cite Juno v. Kite, that written description is going to vary with the nature and scope of the invention, and they don't touch on whether what's going on with Claim 9. All right, so then Xencor files a supplemental amendment on August the 4th, 2025. In the same application, they're trying to basically keep Claim 9, but delete the preamble. And that amendment was not able to be entered because technically, I think the prosecution was considered closed because of the Federal Circuit decision. So then Xencor turns around, files a new application, right? Sort of refiles Claim 9, this time styled as just an antibody claim, not a method of treating claim. And here you have an antibody comprising a means for binding human C5 and an FC domain comprising these two substitutions. Okay, so aside from taking out the preamble, notice that they also took out the other functional limitation that the antibody with the LS substitutions has a greater in vivo half-life, right? So they've even taken out that functional. Now it's literally just an antibody that binds human C5 and has these two substitutions. Okay, so this claim was allowed, and it issued in December 2025. And Xencor then turns around, issues a press release, and says, we're expecting to get $100 to $120 million in royalties on ravulizumab, also known as Ultomiris. And a few months later, 3 months later, Alexion, which by that point had been bought by AstraZeneca, notifies Xencor that it's going to cease U.S. royalty payments and disputes having any additional royalty obligations for Ultomiris. So, if this dispute, does not get settled, it may end up in yet another round of litigation that would probably also, again, be setting some really important precedent for us. Okay, so before I forget, I do want to go back real quick and just remind people, one of the lessons, right, from this whole saga is that, when you're drafting your means plus function claims, you do need to draft the entire claim with 112 in mind, and do be careful of the preambles, because clearly that really had a negative effect, right, on this claim in this whole first part of the litigation. Okay, so a single MPF claim with one corresponding structure covered equivalence by operation of law. And, basically that single claim is what stands between Xencor and, 9 figures in royalties. We'll see how that story ends, but, clearly I hope people get the sense that, when used wisely, this can be a powerful claim drafting strategy. Bear in mind that they were very strategic about how they did it. In Xencor, right, they had only 2 claims, right, in the whole application to simplify prosecution. So this was a very targeted litigation-focused strategy, and not everyone is going to be wanting to take those kinds of chances, right? with their portfolios, but they obviously they had a very good reason to try to be doing this, and so far it seems to have worked out for them. Okay, so now let's look at a case where MPF claims actually succeeded in prosecution, as opposed to having to go through and get succeeding through the end result of amending the claim and going back. Ex parte cleave is a case where MPF is being used for in the antisense oligonucleotide area and also in the siRNA area, and it gives us sort of a complementary model for how MPF claiming works in practice. I won't spend quite as much time on this case because I know we're getting close to time, but let me just run through the highlights here. Okay, so this case involved a patent application claiming pharmaceutical compositions containing antisense oligos and siRNA molecules that reduce expression of heat shock protein 27 in cancer cells. Right? And the context here is that this HSP27 is overexpression is associated with resistance to chemotherapy. So if you reduce HSP27 levels, you sensitize cancer cells to treatment. And I've just put the sort of the relevant for our purposes part of the claim here. It was a claim to a pharmaceutical composition comprising means for reducing the amount of active HSP27 in cancer cells. Okay, so after years of prosecution, which their conventional claims had faced Section 112 rejections, the applicants in Gleave, adopted an MPF claim format, and so that's one of those MPF claims was Claim 33. Okay, so the PTAB, the examiner had rejected the claim. This gets up to the PTAB, and they identified two corresponding structures in the specification. The first one on the left is example 1 in the spec, talked about specific antisense oligos complementary to HSP27 mRNA, and the mechanism that they operated to perform the claim function was to bind that mRNA, block translation, and reduce HSP27 protein levels. And then the other corresponding structure in the specification, right, that performed the claimed function, and that was detailed in example 5 of the spec. And those were specific siRNAs targeting HSP27. And that mechanism was post-transcriptional gene silencing via the RISC complex, and that would result in degrading HSP27 mRNA. Okay, so there's two structurally distinct molecular classes here, right? Single-stranded DNA and double-stranded RNA, both linked to the same claimed function of reducing active HSP27 in cancer cells. So I want to highlight that having two corresponding structures from two different sort of molecular classes strengthened the means plus function argument here. It showed the board that the function could be performed by structurally diverse molecules, and it broadened the base from which the equivalence analysis could proceed. So when you're drafting, think about whether you can disclose multiple corresponding structures. Now, it's not required, right? Because that's what Chamberlain proved, that you only need one, but it certainly can make your claim more robust. Okay, so the PTAB reversed the anticipation and obviousness rejections, and their critical finding really was that the examiner failed to demonstrate that the prior art nucleotide sequence performed the claim function of reducing active HSP27. So it was helpful because, it tells us that the examiner has to show that the prior art discloses the corresponding structure or its equivalent performing the claimed function, right? So here, the prior art taught a nucleotide sequence, but not the specific function of reducing HSP27. So the narrow construction of the means plus function limitation protected the applicant from broad prior art that didn't actually perform the claimed function, right? So this is a key sort of learning from this case is that MPF claims, can be construed to have a narrower scope and make it harder for the examiner to find anticipatory prior art. Okay, so here are some lessons from Gleave. You can get satisfactory scope even though the claims are a bit narrower. It can still give you meaningful protection because you've got some corresponding structures that you've disclosed, and you have the equivalence that the statute's giving you. You need to carefully link your means for language to your specification embodiments. I think Gleave succeeded because examples 1 and 5 were explicitly tied to reducing HSP 27 levels. And it can create, MPF strategies can create design around uncertainty because the competitors can't easily determine the scope of equivalence, right? Which that can create some defensive value beyond your literal claim scope. You should probably expect some examiner resistance, right? In the biotech art units, because MPF claims are still uncommon in biotech patent prosecution. So you need to be ready to educate them on the 112F claim work if need be. Okay, I won't think we've gotten this. Okay, so now we'll look at how MPF claiming can also be used in the chemical sciences. And I've picked one example of MPF claim limitations being used in the context of a pharmaceutical formulation. So I'll give everyone a second to look at claim 1 from this pharmaceutical formulation patent. Okay, so you can see we've got a claim to a pharmaceutical composition comprising one of these listed poloxamers or a mixture thereof, and a means for keeping the pharmaceutical composition in liquid phase up to a temperature of about 40 degrees Celsius in vitro, right? Wherein the composition is for use in lifting mucosal lesions, right? So this is basically a compositions that surgeons would use when they are trying to remove, polyps and lesions, and they would inject the polyps they used to inject them with like a saline solution in order to kind of lift up the polyp so that they would be able to excise it more easily. But the saline solutions would basically, they wouldn't keep the shape. When you lift up the polyp, it would just kind of flatten out really quickly. So they needed something that could keep its shape at sort of these warmer temperatures. And they used a means plus function limitation in their strategy, because basically this allowed them to protect the specific solution without requiring exhaustive genus type disclosure of all possible excipient combinations, right? So you've again, you're following the 112F format. You've got your means for, you have your function, but you tell them what performs the function in your specification. So this is what I think of as like a natural application of means plus function claiming in sort of more of a chemical sciences area. Formulation science involves functional relationships between excipients and physical properties, right? And by using your means plus function format, you avoid the need to claim every single possible excipient combination that achieves temperature stability, right? So it can be a way to sort of, be creative and, capture these other formulations that have this, that achieve this function. Okay. Okay, real quick, I'll just go over, I think that, the key differences in, using MPF in the biological versus chemical arenas is it really has to do with predictability, right? So, on the biology side, we know that a single amino acid change can, completely abolish function. And, for example, the Xencor LS substitutions, right, that extend platform, it worked in many antibodies, but it also didn't work in some others, right? So it's the predictability that, I think is different. In my sense, in the chemical arena, if you generally have a better understanding of sort of the structure activity relationship, then that actually works well for them because I think it means that your equivalence that you're able to get may be broader, right? If your SAR is well characterized. On the biotech side, we really need some clear guidance, right? How is this equivalence analysis going to work, and what kind of differences are going to be considered, substantial, or what's going to be considered insubstantial. But there's still plenty of places, on the chemical side where you've got formulations, you've got, PROTACs, you've got drug conjugates, lots of different places where you can apply means plus function claiming sort of strategically. And, just things to watch out for is just make sure that you're not inadvertently, right, landing yourself in 112F territory. If you want to be in 112F territory, be sort of use means for, right? That's like the safest route. And for us on the biotech side, right, just be aware that our equivalents might be interpreted very narrowly because of the unpredictability. Okay, so that brings us to our recommendations. And here I will just briefly mention, make sure you link your structures to your claimed functions. Try to provide multiple corresponding structures like they did in ex parte Gleave. And also try to characterize, if you can, why the structure performs the function. And obviously, the more working examples and data you can include, all the better. And of course, be wary of your preambles. You're treating patients, make sure that you're not putting that in your claims without, checking whether you really have support for that. For claim drafting, obviously a layered approach is the way to go, right? Try to be deliberate when you use means for, avoid overbroad preambles, and try to figure out a way to incorporate these strategies, right? To give yourself some intermediate scope, right? It's not as narrow as a picture claim, right? But I think an MPF claim is slightly broader than a picture claim, in my view, depending on how you draft it. It's they're not going to be, I think, as big as the genus claims, but they're also not going to be as risky. Just some quick tips on how you respond to the examiner. I'll let people sort of reference this on their own, but the key one is, make sure that if they're not being explicit about how they're interpreting your means plus function limitation, they really need to. And, both the memo and the regs, make that pretty explicit, right? So they need to be putting how they're interpreting your means plus function limitation and the corresponding structures into the record. Okay, and here's some examiner resistance that you might encounter. One disclosed antibody can't be sufficient, right? And no, actually, the appeals review panel expressly held that one antibody, eculizumab, was sufficient. And Gleave actually had two different molecular classes, both of which were deemed sufficient. So there's things you can say. You may get a sort of, some pushback because of this issue of, hey, how does 112F, it feels like it's trying to circumvent the, enablement written description requirements of 112. And I think the answer is that this is a different statute with a different part of the statute with different requirements. Okay, it's not a workaround. It's not a cheating method. It's a distinct claiming tool, right? That has its own framework set up. Okay, and I think we've been through our key takeaways. Really, if anything, I hope people have left today feeling like, maybe this is a tool that is worth taking a closer look at. And we hope that you got something really useful out of all this. And, please, I'd like to open it up now for questions. Sorry for going a teeny bit over.
Great job, Alex. I have some questions for you from the audience. So I think you touched a couple times generally on some of the advantage that can stem from using means plus function claiming over sort of conventional claiming style. We have a question that kind of asks you to think about some of the specific advantages of one of the patents you discussed. So the question is, in the Zen core patent, what does means plus function claiming get you in terms of patentability and claim scope that a claim simply to an anti-C5 antibody with the LS modification would not get you? So why did they go after? Why were they so bent on getting a means plus function claim in the Zen core patent? What did they get? What was the advantage of that?
Sure. Well, it was that if they got their means plus function claim, then it was because you only had to disclose one equivalent, right? One example of a structure that performs that claimed function. If that would just be a normal genus claim, right, without using the words means for, right, then you're back in Amgen versus Sanofi, right, Juno v. Kiteland. You're going to have to show examples of that go all across your genus, right? So think about that in terms of, we were talking about how hard is it, right, to have really full disclosure when you have a genus claim that could cover millions of embodiments, right? Well, your 112F claim, it's not going to get you millions of equivalents, right? I mean, equivalents, right, they have to be close, right? But you still got some wiggle room there, and you don't have to, it's the level of disclosure required, really. That's why. And when I showed you the spec, right, you saw that there really was only one line out of this whole entire, right, patent specification and it mentions just the antibody by name, 5G 1.1. That would not be enough to satisfy, written description or enablement, really, right? It's not enough, but it is enough under the 112F standard. So for me, that's how I see it. That's why they had to go in that direction, because really the spec was thin.
Interesting. A couple questions here that are interesting to me too from the audience regarding how to use means plus function claiming as far as where the means plus function goes between the independent and dependent claims. So if means plus function and non-means plus function independent/dependent claims are combined together, does this tempt a restriction requirement? And does this tempt restriction or election of species requirements? And is there a response strategy you recommend, or a drafting strategy with regard to restriction and election of species when using means plus function claiming that you recommend for maximizing the number of examined claims?
I'd have to think about that one. That's a pretty tough one. And my gut sense, just sort of off the top of my head, is if the means plus function claim is basically, it narrows, right, the applicable prior art. My sense is it might, yeah, some examiners might say, well, hey, I've got, I have to look at different prior art for this than I do for the other types of claims. So they may try to claim, this is a reason, but to be honest, that's really something that I don't know yet, and I haven't seen any case law on it yet. That might take some digging to find out, has it happened and how have people handled that in the past.
Here's a related question. With regard to the layering structure you recommend in a previous slide, the question is, do you create layer 1 as dependent claims from layer 2, the means plus function claims, or is layer 1 created as independent claims?
Yeah, my preference is to put them in as, it's kind of a useful in a limited way, right? I don't bring it in as claim 1, right? Like they did in Zencore, because that's all they wanted to do. No, I would just bring it in, for me, just bring it in when you've got maybe, one issue, sort of side issue, where you don't have that much description in the spec, but you're still sort of trying to get a little bit of extra coverage, right? So for me, it's definitely something that you bring in kind of in the middle, closer towards the end, on the narrower side. I don't think there's enough experience yet, right, with how these claims are treated to, to sort of give it your independent claim status.
Interesting. Well, this question sort of implies some of the advantages of means plus function claiming that you mentioned. The question is, means plus function claims in the chemical field are uncommon, but obviously present challenges for searching and FTO analysis. And perhaps this is a hard question to answer, but how do you mitigate the risk of missing important references in FTO searching for chemical compositions? I assume the same question comes about in the biological sciences field also, but any thoughts on that?
Okay, so let me just make sure I understood the question. So you're saying, how do you make sure that you're not missing important references in FTO searches because those references employ means plus function claiming strategies?
Well, I
Is
think
that
it's
the
because
question?
the claims you're performing the FTO analysis on have a means plus function claiming style. How do you search for prior art or oh no, I see what your question is. Maybe the question asks the questioner intended to ask about um, validity searching. Um, hmm.
Yeah, I mean, I do. I think just off the, I'll say for me, I certainly can see the issue, right? Because if you're doing a search for claims that might cover, let's pretend you're doing a search for claims that might cover your own product, right? Well, typically, right, the way that's done is we search for, okay, well, let's look for claims that mention your product's name, right? Your product sequences, your product's, right, characteristics. And so you're looking for claims that sort of recite your structure, right? Because that's what, right, most typical claims do, right? But now you'd be looking for really, a means for binding, human C5 protein. Well, the only way you're going to catch that, it's going to mention you in the specification, right? So yeah, you'd have to be making sure that your searches are covering, looking for your name, your structure, your sequence in the specification, right? And hopefully the connection between the function that's recited in the claim, right, and the function that your product performs, I guess, that's going to be critical, right? I think the only way you're going to catch those is making sure that you're keywords associated with functions are really right comprehensive, right? Because it's true, yeah, it's I could see how that does present a risk, right? You might miss it, right? If the keyword search is not comprehensive enough.
Yeah, interesting. So the specification support requirements for means plus function claiming somewhat mitigate, I think, the initial fear there, which is that when you see a claim that just requires a certain function, you would have to also search for that function, in issued patents. But the fact
Mm-hmm.
is, such a claim requires sufficient support and specification, which somewhat mitigates that risk. Well, that's very interesting. Um, well, Alex, I think you did a fantastic job. This will be the end of our session today. If you do have any additional questions, please feel free to email me or Alex. And again, a link to the slides for today's presentation will be emailed to you. And I hope you will tune in to future additional episodes of the SLW Chemistry and Biology Seminar Series. Thank you so much for your attention today.